Good evening, all. My name is Toon Nguyen. I'm the Executive Director of OCA Asian Pacific American Advocates. Welcome to our two-part webinar series on being American and the history of anti-Asian laws. Today is our talk on paperwork as power, where we have three legal scholars review how paperwork is wielded as power in this country. For those of you who don't know, OCA is currently in a lawsuit represented by the Washington Lawyers Committee and Asian Americans Advancing Justice, AAJC, to protect birthright citizenship. We hope that this two-part webinar series will help educate our members and audience on the concept and history of citizenship, paperwork in this country, and why such lawsuits are important. Our scholars today will speak on some important legal cases from the past, share their thoughts on belonging, surveillance, and the American democracy, and at the end, we'll have some time for questions from the audience. So please feel free to share your thoughts in the chat, engage with what our panelists are sharing, send your questions via the Q&A function at the bottom of your Zoom screen or in the chat. We'll get to them towards the end. Now it's my pleasure to turn it over to the moderator for today's conversation, Joshua Tran, who is a former OCA Policy Fellow, currently an NCAPA Legal Fellow, and a 3L at Duke University School of Law.
Hello, everybody. I'm thrilled to be moderating today's conversation. This is why I'm excited about this topic in particular. We often think about exclusion and discrimination as dramatic and overt acts, such as bans, proclamations, and violence. But some of the most powerful tools of control have been bureaucratic. They've been neutral, necessary, even objective, um, a form you have to fill out. But tonight, we're going to trace how these tools have been weaponized throughout US history, from the Page Act of 1875 to the Geary Act of 1892 to the systems we see today. And we're going to hear from three incredible scholars who have dedicated their careers to understanding this history and what it means for us now. So it's my pleasure to introduce our panelists. First, Dr. Ming Ngai, professor of history at Columbia University, author of Impossible Subjects, and a leading expert on immigration history and racialized citizenship. Dr. Ngai, what are you working on right now that you're excited about?
Good evening. Thank you, Joshua, and thank you to OCA and to everybody in the audience who's taking the time to tune in tonight. I really appreciate that. Right now, I'm trying to finish a book. It's called A Nation of Immigrants, A Short History of an Idea. And it is a political and intellectual history of how these ideas that we think of as being timeless narratives of American history, how they're actually products of certain political periods. So, Nation of Immigrants is actually a concept that was born after World War II. Nobody uttered this in the 19th century or early 20th century. And it was part of a political project by European Americans to promote their own inclusion. So, I'll stop there, but that's the book I'm trying to finish right now. Hopefully, it'll be out in a year or so.
Well, thank you, and we look forward to it when it finally releases. Next, Professor Natsu Taylor Saito, whose groundbreaking work on plenary power doctrine has been fundamentally reshaped how we understand constitutional law and civil rights. Professor, what's on your mind these days?
Thank you. There's so much going on, but I've been thinking a lot about the history of the United States and how the ways in which peoples have been racialized, and that has been used to both include and exclude folks. So that fits in very well with the work you all are doing. I've been working a little bit on a lawsuit that's also similar to the birthright citizenship one, in that challenging the Alien Enemies Act use. And then I've also been working with local efforts for redress and reparations, because I think it's really important for those of us who have been the beneficiaries of at least some kind of redress to be working with other groups who are also struggling to have the wrongs that have been perpetrated against them recognized.
Thank you, Professor. And last, Dr. Xiaojin Zhao, Associate Professor in the Department of Asian American Studies at UC Santa Barbara. historian of Chinese America and the experiences of Asian American women under restrictive immigration laws. Dr. Zhao, what brings you to this conversation today?
Well, I'm a U.S. historian, as you said, and it's an honor to be here. Recently retired, tried to finish, after 30 some years teaching at the UC Santa Barbara. Currently, I'm just finishing an essay about early Chinese immigration, still figuring out what to do next. It's really a lot is going on, but I'm really glad to be part of the conversation today here.
Well, glad to have all three of you join us tonight. So tonight, we're going to explore three key questions. First, how did bureaucratic exclusion work historically? Second, what legal foundations enabled it? And third, how do we see it today? And crucially, what does history teach us about resisting what is happening? So let's go ahead and dive in. So the first question is to Dr. Zhao. The question is, the Page Act of 1875 framed Chinese women as morally suspect, assumed to be prostitutes or threats to morality, which restricted their migration and fragmented families for generations. Can you give us a brief history of gendered suspicion in immigration policies, and what can history teach us about how narratives about deserving migrants still operate today?
Okay, let me start with some background information. The Chinese start to come to California in 1849, and most of the early arrivals were male, like gold miners from other parts of the world. These immigrants did not bring their wives and their children in the early years. A large proportion of female immigrants from China in those days were young women who had been sold into prostitution. There were prostitutes of different race and color in Gold Rush, California, and the American West. But this image of Chinese women as prostitutes and disease carriers who would infect white men incurable diseases such as syphilis, for example, was created and instilled in the minds of the American public. In 1870, the state legislature passed a law to prevent the kidnapping and the importation of Mongolia, Chinese, and Japanese females for criminal or demoralizing purposes. And the Chinese brought the case to the court, and the U.S. Supreme Court eventually declared the law unconstitutional in 1874. But a year later, the Page Law was passed, which forbade the entry of Chinese, Japanese, and Mongolia contract laborers, prostitutes, and felons. The law effectively blocked the entry of Chinese women. Technically, the Page Law stipulated an end to the importation of contract laborers and prostitutes, but its strict implementation made it extremely difficult for wives of Chinese immigrants to come to the U.S. Chinese women were charged fees for their applications. They also had to undergo physical and oral examinations by the American consuls in Hong Kong. The questions that they had to answer were harsh, which were designed with the assumption that all Chinese women were prostitutes, and that the applicants themselves had to prove otherwise. The combination of the financial burden and the humiliation that they were subject to discouraged many Chinese wives of the immigrants from going through the process. From 1869 to 1874, an annual average of 626 Chinese women were admitted. The number was reduced to 265 for the 5-year period after the Page Law. The law was so effectively enforced that the immigration of Chinese women became a non-issue in the later campaigns to exclude the Chinese. Chinese exclusion laws effective from 1882 to 1943 barred the entry of Chinese laborers. The law did not mention women specifically because they were already excluded by the Page Law. There was room for interpretations, though. Since Chinese women did not usually work for wages in those days, one would think that they should not be considered laborers. Therefore, wives of those already in the US before 1882 should be able to send for their wives in China. Chinese exclusion laws were clearly against the family unification. Soon after, a federal circuit court ruled that the wives and children who had not adopted the occupation of laborers should be deemed to belong to the class to which the husband or father belongs. In other words, a woman should be accorded labor status upon her marriage to a laborer, even if she had never worked outside home. The US government, in the meantime, tightened Chinese immigration further through a number of exclusion amendments. Most damaging to the Chinese American community is the 1888 Scott Act, which denied the re-entry of Chinese who were visiting their families in China. The law basically forced male Chinese immigrants to separate from their wives and children permanently unless they choose to leave and never return. To Chinese immigrants, these laws were passed to separate families, reduce the Chinese population, and eventually rid the country of all Chinese. Exclusion laws were selective in terms of class as well. During the exclusion, Chinese merchants were allowed to come. The same applied to female immigrants. While wives of Chinese laborers were barred, wives of merchants were admissible. It became very clear to the Chinese immigrant community that if they want to survive, they would have to find ways to bring women. And much of the struggle of the community during the exclusion was for family unification using merchant status and later, after Wang Art in 1898, citizenship status to bring family members. I will stop here.
So what you're saying is that the Page Act and other exclusion laws that followed it wasn't just law. It sounds like it was a story about who the American government thought belonged through legal mechanisms. Is that right?
Mm-hmm.
Well, thank you for that important context, Dr. Zhao. Um, the second question is to Professor Saito. The question is, your work traces how plenary power, the doctrine that Congress has virtually unlimited authority over immigration and national security rationales, have justified unequal treatment of racialized groups throughout the United States history. How do these legal foundations continue to shape government surveillance, detention, and discretionary power today?
They still continue in very direct and concrete ways. And I think it's important to understand these powers in the context of the history that we were just that was just shared with us, and also the broader history of the construction of the United States and who was intended to be included and excluded in that process. So as you said, plenary power means full, absolute, total power, and it's a legal doctrine that was first openly named in the Chinese exclusion cases. And it says that Congress and the executive branch, the political branches of government, have absolute power over certain areas of the law. And normally we think of constitutional protections as overriding laws, other kinds of laws. We think that whatever happens, we can always appeal to constitutional protections. But what the plenary power doctrine says is that despite the Constitution, in these areas of law, if Congress and the executive act, the courts will not intervene. So they won't intervene to ensure constitutional protections, and they won't intervene when the United States is violating a treaty, which under the Constitution, of course, is supposed to be part of the supreme law of the land. And so we have this doctrine being articulated in the Chinese exclusion cases in Downs versus Bidwell, which is a case about Puerto Rico and external U.S. colonies, and whether the Constitution would apply to externally held territories. In other words, land that the United States completely controls but is not incorporated as a state. And it's also applied with respect to American Indian nations. Now, if you think about that, right, it's immigrants colonized peoples, and American Indians. Those are all groups that are seen as not part of the polity, that have been excluded. And this gets us back to really even before the plenary power doctrine is introduced, the notion of who's supposed to be an American. And this is, I believe, most accurately characterized as a settler colonial state. And that means that the settlers came, the European settlers, came and established a state of their own making on land that was already occupied by somebody else and that didn't belong to them. And so part of this process is, creating the framework for asserting their sovereignty and their prerogative to have complete control over their claimed territory, which has certain boundaries or borders. And one of the first things that they do, right, is the Constitution doesn't say anything about who's a citizen, and except that it says Congress shall enact a uniform rule of naturalization. So in 1790, the very first Congress does enact a law of naturalization that says only, quote, free white persons can become naturalized citizens. There were other restrictions as well, like you had to have lived here so long and be of good moral character, etc. But that racial restriction on citizenship doesn't go away until 1952. And so we have from the beginning, it goes away in bits and pieces, but it doesn't totally go away until 1952. So we have from the beginning very clear directives of who is supposed to belong here and who's not. And this laid the foundation for this absolute use of power, that the justification was highly, highly racialized, right? And in all of these cases, but we see it very starkly in the Chinese exclusion cases, this notion that you mentioned of necessity, right? Or, the importance of protecting the sanctity of the state and its borders and the country's sovereignty. That is raised in a very racialized manner, and it really means keeping out people who are not perceived as belonging, which for most of the history of the United States has meant white people. And so these principles, if you look back at the cases, they're founded on very racialized logic that we would never, I don't think, overtly rely on today. And yet they still form the foundation for what's happening today. The plenary power doctrine in immigration, right, is the reason that they can have these detention without, warrant, without any of the sort of due process protections that we otherwise think are, go along with arrests, without the protections that have to do with trials and, any kind of sort of constitutionally based fairness, other than they nod to due process, but then they turn around and say the process that's due is whatever Congress says is due. And so it's not our normal, what we think of as constitutional due process. And so in those cases, that's what has allowed the Guantanamo detainees. That's what allowed the Haitians to be detained back, starting, in the 80s and forward. That's what has allowed right now, children to be held in cages at the border. That's what is allowing the current immigration sweeps, is this notion that the government can do whatever it claims is necessary in the name of protecting the national security. And these cases provide the legal foundations for that, and they're still relied upon. And even when they're not explicitly relied upon, they, we make a big deal about precedent in law, right? And so if you trace the justifications for these actions, the current actions in immigration law, they trace back to a case, which traces to a case, which traces to another case, which ends up with these early, highly racialized plenary power cases. So I'll stop there.
I see. So it looks like national security has been weaponized against specific racialized groups, but all under the guise of a neutral system that is delegated to these agencies. And so when we see these modern enforcement practices, given these workplace raids, detention policies, it doesn't sound like those are bugs in the system, but they're features almost enabled by the legal doctrines that already exist. Is that right?
For, for me
Yes.
still? Okay, yes, absolutely. That is absolutely right, that they are not glitches, and it is not even about unequal treatment. It is about outright inclusion and exclusion, which is very different to, we just want to make sure people are being treated the same, right? This is, you belong and then you have equal treatment rights, or you just don't belong and then you essentially have no rights. And that is systemic, and it's framed in these neutral terms, right? It has to do with your nationality. What passport do you hold? Do you have this kind of visa or that kind of visa? And, did you cross the border at this particular spot or not at this particular spot, right? But all of these are artificial constructions framed in very neutral language, but designed to maintain the status quo. And it is a status quo that, since the beginning, has been very much unequal and designed to exclude those, or to only allow people in to the extent that they're deemed necessary at this particular moment, and then be able to get rid of them, to turn groups of people into disposable parts of the population.
That's very enlightening. Thank you. Dr. Ngai, your question. The 1892 Geary Act required that Chinese residents carry proof of registration at all times. It was an early internal enforcement mechanism, and police could demand papers anywhere. How do you see that legacy reflected in modern ID requirements, workplace verification systems, or deportation enforcement today? What's changed since then and what hasn't?
Okay, before I get to the Geary Act, I just want to elaborate a little bit on what my colleagues have said, excuse me, and give just a little bit more background on plenary power and exclusion. We have to understand that before 1875, there was no federal regulation of immigration. It was done by the states. And the reason why it took so long for federal policy to regulate immigration was because of the slavery in the South and the difference between North and South. And the South didn't want anybody telling them who could move, meaning their property. So this was stalled until after the Civil War. And in 1875, the Supreme Court ruled in two different cases. One of them was a Chinese case, that immigration was a matter of federal regulation. And when it did that, it put federal power under the Commerce Clause of the Constitution, right? Our system of federalism mandates that all federal laws have to have a justification in the Constitution, right? The states are mostly responsible for police powers, crime, et cetera, et cetera. But federal laws have to have a justification in the Constitution. So in 1875, they put that in the Commerce Clause, which, it's a reasonable explanation. And it's with Chinese exclusion that the system pivots to this question of national security. So in order to justify a racist law, which they were very open that we don't want the Chinese here, they created this plenary power over national security. We don't have plenary power over commerce, right? But we do have it over matters of national security. And so immigration became in the same bucket of things like declaring war, making treaties, right, and immigration. And in the case that established this in 1889, the court said, even though we have no open hostilities with China, it doesn't matter. We don't want them anyway. And if we were at war, it would just make the situation even more urgent. So it declared that Chinese immigrants were agents of a foreign power, and we don't like them. We don't want them. because if there were a war, they would be very dangerous. And that idea that immigrants are potentially all enemy agents is what underlies our immigration law today, not just for Asians, but for all immigrants. And that's why you see the kinds of really outrageous attacks on immigrants and even people who are legal immigrants, even citizens, by ICE and the Border Patrol. So I just wanted to add to what Professor Saito and Professor Zhao have said about the gravity of racism in our immigration laws that comes out of the Chinese cases and then expands to everybody else. So the Geary Act in 1892, the Chinese exclusion law had to be renewed every 10 years. So when they renewed it in 1892, they added a whole bunch of stuff. And one of them was that you had to carry proof, you had to register and carry your registration with you at all times. And if you were found to be without it, you could protest, but you had to have 3 white witnesses to say who you were. And just parenthetically, I want to say that the thing about this registration requirement is there was a huge boycott. Chinese Americans refused to register, and it went to court, and so they really were not able to force everybody to register. So for decades later, not everybody had the so-called certificate. But what I want to say about this is in relationship to our theme of paper as power, is that why does the government want you to register? Why does the government want to know who you are, where you are? And this is, I think the basic principle here is that all governments, in order to have power over the population, they have to know who is the population. So the first iteration of this is you could think about the census. The census identifies every person, and the purpose is to so it can tax you, and also to figure out your representation, the proportional representation in the Congress, right? So in order to manage, tax, and control a population, it has to make that population visible to the state, right? Now, registration in terms of documents that one has to carry, that has a whole other layer of surveillance and control attached to it. This is about regulating mobility. You could think of a visa or a passport in that way, right? Who can leave the country, who could enter the country. But internally, I want you to think about what was necessary during slavery. For enslaved people to leave a plantation to work or on an errand for their master or whatever, they had to have a pass. And if they didn't have a pass, they were subject to beating, violent return, even death, right? So the pass was really important in order to move about, right? If you were a free Black person, if you were not enslaved, you had to have those papers to prove that you were not an enslaved person. So this was a huge part of the bureaucracy, local and state level bureaucracies that controlled the enslaved population in the South. In the 20th century, there were people who wanted to have immigrants carry papers. And for decades, immigrant advocates objected to this. And it was not until 1940 that the Congress passed the Alien Registration Act. And now every legal alien, every legal immigrant has to, people with green cards, you have to register and you have to carry that with you. And nowadays, when ICE stops people, if you don't have papers, if you don't have proof showing that you are legal, you will be detained. Now, here's the catch, though. That's true. Immigrants are supposed to carry documentation as to their status. Citizens are not required to carry anything. I'm a citizen. I was born in this country. I am not required to carry my birth certificate or passport with me. But if I were stopped and I were asked for my papers, if I said, I don't have to show you anything, I don't have to carry anything, they can still detain me until they determine that I am a citizen. And in this recent wave of sweeps, a lot of, not a small number of citizens have been arrested and detained pending uh, verification of their status. And sometimes this goes on not just for a couple of hours, but for several days. So this is a very dangerous time that we live in. And we could think about the possibility that everybody, regardless of their citizenship, is going to have to carry some identification with them. Right now, a driver's license kind of serves as a purpose of identification. Not everybody has a driver's license, and now you can't even get on an airplane without a certain kind of driver's license that they call a real driver license or a real ID. So I think we are moving rapidly towards a system of really control of the entire population's mobility through documentation. I want to add another point about documentation. People might say, well, it just shows that you're legal, right? What's wrong with that if it shows that you're legal? I want to tell you a story about a student I had in a lecture class I taught some years ago on immigration history. And this young man was a DACA student. He was a DACA holder. And we had an assignment where the students had to um, produce an object, an object from their life or their family's lives, and write a little essay about that object. And he wrote about his DACA card. And he told the story of how he was brought into the country as a very small child by his parents. And he said, most of us, we think DACA was a good thing, right? Because it gave a legal status to all these kids who came in as undocumented children. He said, I hate my DACA card. To me, it's a badge of my exclusion. Even though it gives me the right to work and the right to travel, it says I don't belong here, and I'm only here by the grace of the president. So I think and I had not thought about it in that way, and I really learned from this young man about what it means that you have to carry something with you all the time to show that you have the right to be here. And I think for those of us who are citizens and we don't have that in our own life experience, we don't understand what it's like to have to carry something. And that's why I think after the Geary Act was passed, as the Chinese leadership, the Chinese Consolidated Benevolent Association, the so-called six companies in California, they declared a campaign, do not register. Do not register, because they knew what it meant. They knew it was a badge of exclusion, it was a badge of humiliation, and thousands of people refused to register. Now, over time, eventually, a lot of people did. The boycott didn't last forever. But I think it was remarkable resistance by the Chinese themselves and by their leaders, because they understood what it meant that you have to carry something to prove that you belong here, when that not everybody has to do that. Now we're approaching a time when everybody has to do that. So we'll see how all the Americans feel about that when that comes to pass. But that's already happening in many of our cities today.
Thank you.
So I'll stop there.
That was a lot, and it's something to continue to look out for and to prepare for. Next question, I'm going to open up to all speakers. That question is, exclusion often operated through quiet tools, such as paperwork, licensing requirements, property laws, occupational restrictions, rather than overt bans. Which of these levers feels most visible or most powerful in the United States law and policy today, and what concerns you the most?
I'll start. I'll just kick off with a comment. I just mentioned how people are being arrested and detained regardless of their status. And I see all these videos of ICE snatching people out of Home Depot parking lots, they're not asking for your papers. They don't say, show me your papers. They just grab them. And it's obviously racial profiling of Latinx men. They're grabbing people at the bus stop who are going to work. They're grabbing people off the street. And so it's a funny thing because we've just been talking about how having to carry your papers is a mark of exclusion. But right now, they're not even asking for your papers. I mean, sometimes they do, but in a lot of cases, not just in Los Angeles and Washington, D.C., and New York City, they're grabbing people and they're not asking for their papers. In New York City, they're in the ICE is in the federal courthouse and they're grabbing people who are showing up for asylum hearings. These are asylum seekers who have every right to be here and to go before the court and to explain their case. And what happens because of the bureaucracies, they often are told by the judge, come back on another day. And so there's cases still unresolved. It's an open case. They haven't been denied. And they walk out of the courtroom and ICE snatches them. And so I think this is very frightening because we just had this whole discussion about documentation and paper, and I went on and on about slaves having to have passes and DACA cards. I don't know, sometimes now we're in this very scary place where they don't even ask you for your papers. They just take you.
Yeah,
That is very frightening.
I
I don't know
think
if my colleagues want to comment on this.
I think that's a really, really important point. I wanted to say a minute ago when you were talking about all of us having to carry papers, I was reminded of when my dad's family was interned during World War II, and when my uncle was released from camp to go to college, and he had to travel across the country, they gave him. I have a copy of this paper from his FBI file
Wow.
that is like a, a, a leave. It's like a pass, and it really reminded me of those passes you're talking about from people who were enslaved and also in apartheid South Africa, right? This pass that you had to carry with you as you traveled. And not only did it say that he was allowed to travel from the camp to where he was going to college, but he had to be in the company of a Caucasian member of the armed services. So it explicitly said not only does a soldier have to go with you, it has to be a white soldier. It
Wow.
explicitly said that, which I just thought was really interesting. And I bring up that point to say that, that was only a sector of citizens, right? He was born and raised here, was a US citizen. But it was very easy for the government to claim military necessity and turn on a particular racialized group. And so, even we have that example of a sector of citizens being pretty much overnight turned into others who also had to carry this documentation, which I think just reinforces your point about there's nothing sort of sacred about citizenship that's going to protect, those of us who are sitting back and saying, well, it's not going to hurt us. But I also wanted to comment on the point you raised about they're not even looking at the papers. And I've been thinking about that a lot because you've done amazing work on that transition to requiring papers. And I've been wondering recently if we're now sort of coming full circle back to, it used to be we could eyeball you and see if you belonged or not and take action against you if you want, or if we want. And then we transitioned to the supposedly more sort of proper system of paperwork, which was also highly racialized, but looked more objective and neutral. And there was a system and it was law at work rather than just bias or, exclusion. And now it seems like we're going back to it. it's the physical bodies that are the targets, and the paperwork really doesn't matter all that much.
Yeah, we're not quite
Oh,
we're not quite
please.
there yet, but you can see this is a trend, right? I'm sorry, Professor Zhao.
Well, yeah, thank you. Um, I'm thinking about different tools that the government used in addition, from a historical perspective, in addition to the laws and the court cases. One kind of this quite tools was used used in the system of screening immigrant applicants at the port of entry. When the officials have the opportunity to inspect, interrogate the newcomers before making the final call for their admissibility. And one interesting thing that happened in the past, those interrogations were extremely much harsher for women than men. So previously talked about the wives of the merchants would be able to come. If the laborers, you wouldn't be able to come. But in addition to prove that your relationship with the man who was eligible in the resident in the United States to bring the wife, either as merchants or as citizens, the women also have to demonstrate that she herself belongs to a class that is higher than the labor class. And what the authority did at the port of entry is to use this, questions and also visual inspection, more specifically looking at, it's ridiculous, looking at the size of the woman's feet. Now we know foot biting in China. This was a symbol of backwardness of feudal Chinese society, and that was already banned in 1911. And the anti-foot biting movement started much earlier. But somehow in the U.S., the immigration authorities considered the women with bound feet as women from the elite class, which would confine them to domesticity and would not work outside home. So that fit into this middle class, this womanhood ideology. So what made it interesting was that some students who were interrogated at the port of entry asking about their wives and their mothers' feet size find very offended, while a lot of women, in order to gain entry, those were women already gained freedom, that were already freed themselves, and they were anti-foot biting. But in order to gain entry to the United States, they would use the same method to tightly wrap their feet, to deform their feet in order to gain entry. I just thought it's really interesting because usually we use this unbound feet as a metaphor to describe the immigration process to immigration to the United States process for Chinese women. But actually, a lot of Chinese women did not unbound their feet before in China, but in order to gain entry, they have to do it otherwise. So coming back to this, the current situation, I also find it very difficult. We are living in a very difficult situation, and a lot of time I find it very difficult to advise students in terms of what to do, especially students who have not gained the citizenship. So, for example, there are conflicting messages in the so on the one side, on the one hand, that for people who come from countries that are identified as an enemy of the United States, um, sometimes were compelled to prove their disloyalty to that country, right? So in one situation, a student from the UC system participated in the demonstration just for the Free Palestinian demonstration, and was arrested by the police. And she quoted by the media saying that she felt great because this was in the U.S., that she was able to exercise her right to demonstrate as a college student. But she was one of the first to be deported, during the current administration. So it's a very difficult situation we are in it now.
Thank you all. Going to move on to the next question, which is related. The bureaucratic exclusion has often been justified as neutral or necessary. It's just how the administration works. And all three of you have touched upon it, but what can history teach us about recognizing those patterns when we see them, and what can it teach us about resisting them?
Honestly, it is very difficult in terms of giving students advice, right? So on the one hand, I would like to say that as students, you should do whatever you feel you you want to do. But on the other hand, I also know the risk to the students, especially for those who did not have citizenship. They did not have the paperwork here.
The bureaucracy is always a kind of double-edged thing. I mean, we're talking about it mostly in terms of the control that it exerts on people, on immigrants and others. But also, immigrants have historically turned the bureaucracy around to their own benefit, right? I mean, we have Asian Americans all know about the paper sons, right, who created their own paper. They created a whole paper trail of fake citizens based on a genuine document, right? An initial discharge of somebody in a habeas corpus ruling that they were born in the United States. And then, you've got several generations of people claiming citizenship. So, and we all know, I mean, there's always stuff in the news about, I don't know, immigration marriages, or people who use social security numbers, that aren't theirs. So there's always a pushback. Um, and I don't judge. I'm not into judging people um, who maybe have doctored papers or whatever. A lot of Chinese who were engaged in the paper sun uh, documents, they knew it wasn't legal, but they thought exclusion was immoral, right? So there was a larger harm that they felt justified creating these false lineages. So I think bureaucracies always have weak spots, underbellies. They cannot account for every single contingency. They cannot control people absolutely 100% all of the time. So people always push back. But I think what makes this moment particularly difficult is that we don't even know what the rules are anymore. The rules seem to change day to day, person to person, country to country. And so as Professor Zhao says, it's very hard for us to advise our students. We have international students who they don't know what to do. They don't even know. They ask, should I go home for Christmas? Will I get back in to the country? I can't tell them that they're going to get back in, but I can't say you're not going to get back in. So people all have to weigh these risks. And, I teach at a university which is in the crosshairs of the government right now. So any international student uh, at Columbia, I think, is under faces increased risks, but not everybody is going to be excluded. So I think the reason why it's so hard to advise our students and I have colleagues too who are green card holders. They don't know, should I go visit my family over the holidays? It's very hard to know because the rules are so uh, unclear. I mean, there are rules, but they don't always follow the rules, and we see really egregious violations of people's individual rights. And I think this point about paper being less important or unimportant in certain cases, it's not for everything, but in certain cases. And this return to the body, like, are your feet bound? Or do you have a tattoo that we can say proves you are in a gang that is terrorists? That was the reason they picked up 250 people, Venezuelans, many of whom had legal status, had temporary protected status, and their tattoos had nothing to do with gangs. They had tattoos, for other things. And so this return to the body, I think, is very dangerous. And I think right now it's very fraught because we don't know in any given case what is going to happen because the rules seem to be they go by the rules some days, they don't go by the rules other days, and it depends on who you are, what their agenda is at that moment, whether or not you're unlucky enough to fall into that category. Um, so I don't know how it's going to work out. So far, I just want to add one more thing about why they get away with all this stuff, right? Why do they get away with all this stuff? It's because of the plenary power. I mean, already at the district court level, Trump administration has lost almost every immigration case that's been brought before it. But as it goes up the chain to the appeals courts, he has more wins there, and then we don't know what the Supreme Court's going to do. And the Supreme Court has already ruled, for example, that they can send a deportee to a third country that that person has no connection to. That's very bad because they're sending people to really awful places. Um, so, we don't know how the Supreme Court is going to rule on birthright citizenship. Um, but right now, the law is very uncertain, and that's a big problem.
It is.
One,
Professor Sachter, do you have anything to add before we open up to the audience?
yeah, I just wanted to say that I think that that's a really important point about, we don't have any predictability here. And we are legitimately, calling out the hypocrisy, right, of the government not playing by the rules, while at the same time, the government's claim to be allowed to not play by the rules is that the people who are being victimized by these practices aren't playing by the rules. And so that's a very, contradictory position that's being taken by the government and very confusing. And I think our tendency is to try to insist that everyone play by the rules, which, especially as lawyers, that's our job, right? And that is important. But at the same time, I think we have to hold in our consciousness that the rules are not fair. And I think it's really important that we not buy into these arguments of, well, these people can be excluded because they are, quote, illegal, right? Or they have not complied with X, Y, and Z law. I think if we fall into that trap of well, if they're not here illegally, it's okay to do any of these things, then we are opening up, society to all of these horrors that they're inflicting on people, and that we have to also maintain the consciousness that all of these things, right? Who gets visas and why, and who gets passports and why, who's a citizen and why, all of these things are very arbitrarily imposed to achieve certain ends, which include maintaining a particular highly racialized status quo here. And we can't just go along with, oh, well, there's this nice, clean, legal, illegal distinction.
Thank you. Yeah, thank you all for your insight. So we've opened it up to the audience. So we have a few great questions if anyone wants to hop in. The first is, can the current administration do the same again? Declare a certain population, a certain part of the population, a security risk to the United States. And I believe they're talking about internment there. So is that
Absolutely.
legally permissible? Yes.
Yeah,
I,
they're already doing that. They already said that the Venezuelans associated with a certain gang are terrorists and are enemies. So right now, there's a lot of loose talk in the government. Everybody's an enemy, everybody's a threat. It's such a broad brush that is being painting all immigrants. I mean, they will get up and say, we don't want any immigrants here. We want to get rid of all of them. Doesn't matter if they're legal, illegal. And the justification is that they are a threat to national security. They're a threat to our way of life. They're a threat to our jobs. They have a lot of different reasons, but the number one reason is that they threaten national security. So that's always the justification.
and I think that it's important to remember that Korematsu, which justified allowed the Japanese American internment, really has not been overturned, right? Justice Roberts claimed that it was in Trump versus Hawaii. But if you look at Trump versus Hawaii, they claimed to not be following Korematsu, and then they turned around and did exactly the same thing, which was to go along with what the government said, because the government claimed that it had this military necessity, that it was a matter of national security, and on that basis not question the actual evidence that the government had. And that's exactly what happened in Korematsu. And so that is still the law, that the courts will defer to the government's claim regardless of the evidence to back up that claim.
Very concerning. Next question is from Siwen Law. Do you think that the 1907 Denaturalization Act, subsequently named the Cable Act, will provide the Trump administration with support for denaturalization of United States citizens who were not born in the United States?
They don't need the 1907 Act to do that. They already have people, I think, I don't know if it's the Justice Department or where, checking naturalization files to see if anybody can be denaturalized. You can only be stripped of your naturalized citizenship if you are found to have lied at your naturalization hearing or committed fraud in your naturalization application. Even serving in a foreign army doesn't mean you lose your citizenship. It's very, very specific that only if you had lied on your application or in your hearing can you be stripped of your naturalized citizenship. And it has to be something material. It has to be something like, I said I was never a member of the Nazi Party, but actually they were. It's not like you spelled something wrong, or it's not a typo. But now they are going through all the naturalization files to find evidence. So they're comparing So this is what AI can do very quickly. You can compare the naturalization applications with criminal records to see if somebody had a criminal record. That in itself is not grounds, depending on what the crime was, right? That in itself is not grounds to strip somebody or deny somebody. And then they will go after those people. And so they did this under the first Trump administration, and they dealt with not too many, but they did go after some people. Now I believe they're using much more sophisticated computer softwares to compare, to find gaps in people's records. And if this is somebody that they don't like, right, they're not necessarily going to go after everybody who had a shoplifting charge or something like that. But if it's somebody that they find politically objectionable, they will find something in the record. And so I think this is something we should be very concerned about. And the president has made all kinds of threats. He's going to strip, I don't know, Rosie O'Donnell, Zohran Mamdani, uh, people who are naturalized citizens. He's going to strip them of their citizenship as frauds, right? Because they didn't admit that they were a communist. So all of this is a lot of performance, and bluster. But they do have a unit in the Justice Department looking at naturalization records, and if they find something that they can say is evidence of fraud, even if it's not really the case, we'll have to see what happens with this. There haven't been any cases yet that I know of. Perhaps the other professors know of some cases. But if they're going to go after high-profile people who are naturalized citizens because they don't like their politics, then I think that'll be we'll hear about that.
Mhm.
I do
Professor
think it's
Jod,
important. Oh, I'm sorry.
so sorry, Professor Satter, go ahead.
I just wanted to say I do think it's important that that example of the 1907 Act is important in that it illustrates that Congress can pass laws to change the naturalization rules
Well, that's
in
true. Yes.
and so that is always a danger. We're not at that. They haven't done it right now yet, but they could.
Good point. Yeah.
Next question is when citizens of color are detained and held for days, what legal recourse does one have?
Well, first you have to have a lawyer. When you're being detained by ICE, you don't have a right to a lawyer. Sometimes you don't get a phone call. So that's why we have instances of people who are detained for days before they can get a lawyer. I mean, if you can show that you're a citizen, they have to let you go. But it might take days, it might take weeks. It might involve them having roughed you up, in the meantime. Um, but if you are a citizen and you can show you're a citizen, they cannot keep you.
Few more questions. Roland Twangs asked, is a failure to disclose, such as party membership, treated the same as lying in the naturalization processes? Referring back to the question we had answered not too long ago.
Yeah, if you failed to disclose that you were a member of you were a Nazi, yeah, that's grounds for stripping one of naturalization. The Supreme Court has ruled that mere membership in the Communist Party does not mean uh, that that does not make you a terrorist or it's not grounds. Is that right? Right? It's not grounds for denaturalization. They tried to do that. They did that, and then the court ruled that the philosophy is not the same as advocacy.
Believe those are all the questions we have. Professor Zhao, Saito Ngai, do you have anything to add to this discussion we've had so far?
I just want to say that we are in a very difficult time, but studying history, especially studying the history of Chinese exclusion time period, um, I just think that those immigrants and their communities do so remarkable because they were really in extremely difficult time. They were not allowed to become citizens. They were aliens. They didn't have much of a right at all. But the community never gave up. Uh, and they went to court. Most of their cases failed, but they never stopped. And they also lobby Congress when the number of citizens in the community were extremely small, but they still went and win. Sometimes, most cases they lost. It's not like how many cases they win. It was the effort, and they actually win some cases under those extremely difficult circumstances. It was something that we should not forget.
I
I
just
think
want
that's
to
so important. Yeah. Oh, go ahead. Go ahead.
I was just going to say thank you to both of you for bringing up these examples of resistance, because I think that those are so important, and that's what we have to remember and to support, because we see it happening still today and in all these communities that are under attack, and how important it is to support the resistance everywhere we find it.
And the resistance is it's far and wide among immigrants. It's not always visible, but people in the communities are organized. I got a text alert today that ICE was in New York. It wasn't anywhere near that I could get to, so I couldn't rush over there. But that's another thing about, I think something that is perhaps different today is, as Professor Zhao said, the immigrant communities, we always struggled, we always resisted, we always persisted, but we often didn't have anybody supporting us. We all always had to do it alone, right? When they interned 120,000 Japanese Americans, there's nary a peep, right? Nobody, well, a tiny number of people objected, but really there was no opposition in the American people. And I think today is different. Today, you have ordinary citizens, middle class white people fighting with ICE on the street. I think that's remarkable. They have just gone too far, snatching people off the street, and people aren't having it. In neighborhoods, people are coming out to defend the immigrants. And that gives me a lot of hope, that we might have finally come to a place where citizens will join the resistance to defend non-citizens.
Well, thank you all for a very insightful and extraordinary conversation. My takeaway is that bureaucracy is political and paperwork is power. When a government asks for papers, that's not just a neutral administration, it's an exercise of power with real consequences for real people, as we've discussed. And history shows us that these systems have been resisted before, and people have challenged them legally and organized against them and told counter narratives and sometimes won. Sometimes that's not, but sometimes they do. So as you think about your own work, whether you're an organizer, a funder, a researcher, a student, or just a community member, I hope tonight's conversation helps you recognize when bureaucracy is being weaponized. And I hope it inspires you to think creatively about how we push back. Before we go, I want to make sure that you have the resources to keep the conversation going, and I'm going to turn it over to To for those resources.
Thank you, Josh, for your really wonderful moderating of this conversation tonight. And once again, thank you, Professor Saito, Dr. Zhao, Dr. Ngai, for your time. And honestly, this mini lecture, like to all of our audience members, you're welcome, right? I want to thank our fall policy intern from WashU, Jordan Kim, for developing this webinar series and putting together a fantastic panel of speakers. You can find tonight's webinar on our YouTube by searching OCA National. It'll be up in the next couple of days. And again, to the audience, thank you for tuning in. Email us at oca@ocanational.org if you have any further questions or ideas for future webinars that you're curious about as well. Thank you all and have a great evening.
Thank you.